Appeal number 64, Town of Amherst versus Granite State Insurance. Thank you, Joe. Counsel.
Your Honors, may it please the Court, John Schmidt from Phillips Lytle on behalf of the Town of Amherst. With me today is Nicholas Roscoe, one of my colleagues. I request 1 minute for rebuttal.
You may have 1 minute, sir.
Thank you, Your Honor.
You're welcome.
Your Honor, the issue here today, and the issue that the Fourth Department respectfully erred on, is who decides the gateway issue of arbitrability.
Counsel, is your position that this August 5th agreement is a modification or a waiver?
Both, Your Honor. I'd focus first, and there's another issue. I have a two-part answer to that, Your Honor. The answer is yes. The first part of the explanation is that it is an agreement to litigate. It's an express waiver of the arbitration provision.
But wouldn't that be instead of the arbitration provision? It's not a waiver of the arbitration provision. It seems to me the cases on waiver from this court deal fairly exclusively with conduct. So if you start to litigate an action, you can't turn around and say, no, wait, we're going to arbitrate this, because you've waived that right to arbitrate by engaging in something of the process of court litigation. So our other cases speak to modification where there is a subsequent agreement that, in effect, supersedes an arbitration agreement. So I'm having a little difficulty understanding your position here as to waiver.
Well, Your Honor, first, if the court's going to reach that issue, then not even by implication, by fact, then it's an acceptance of the fact that the court decides that issue. It decides the
But doesn't the decision of that issue have an effect on what this court is going to do with your arbitration issue? Because if it's a waiver, we've said certain things. If it's a modification, we've said certain things about how you resolve, which form resolves the arbitrability issue.
Well, Your Honor, with regard to waiver and signing an agreement, which is pretty clear conduct, much like participating in litigation, but with regard to the modification issue, the cases that Granite cites, in large part, if not exclusively, deal with, they don't deal with challenges to the arbitration provision. They deal with issues related to whether or not the subsequent agreement supersedes the substantive provisions of the original agreement. And here we have a direct challenge as to the enforceability of the arbitration provision. And I'd like to add one other point, Your Honor. Here, we don't just have the written agreement to litigate, but we also have, after this litigation was commenced, an answer with counterclaims by Granite State Insurance Company, an amended answer with counterclaims by Granite State Insurance Company. They tried to serve a late notice of claim. Then they sought leave in the court.
So your argument is that their conduct in that case was a waiver?
The conduct was cumulative, yes, and it resulted in a waiver. And as we stand here today...
Is that what the basis the appellate division went on?
No, the appellate division order at the time dealt with just simply the issue of the agreement to litigate, the litigation agreement.
As I understood the whole waiver or waiver cases, that those cases dealt with implicit waiver, whereas to me, signing an agreement, if it was a waiver, would be an explicit waiver.
Absolutely, Your Honor.
So I don't know. It's a little confusing. That to me, it seems to me that you're sort of melding the two, and you're saying that signing an agreement is conduct like conduct that we've referred to as an implicit waiver. Are they two different things, or are they the same thing? Or I'm not clear what your argument is.
Well, it's an interesting point, Your Honor. And New York's created the commercial part for the efficient disposition of litigation. And oftentimes you face, gee, has conduct created a contract? And here you've got the implied waiver cases. Where
But
the
this
court-
isn't that, is it? I mean, maybe.
This is a contract, yeah,
Yeah.
it's in black and white.
Yeah.
It says we agree to litigate. And the parties did that, and then they did litigate. This case has been concluded. Summary judgment was granted to the town of Amherst. The disputed residue, the $3.13 million, that was granted to the town of Amherst.
Can I switch to the question of who gets to decide this for a moment, and tell me why the following proposition is wrong? The arbitration provision in the policy of insurance says the procedural rules applicable to this arbitration shall, except as provided otherwise herein, be in accordance with the commercial arbitration rules of the AAA. Rule 7 of the AAA commercial rules says jurisdiction. The arbitrator shall have the power to rule on his or her own jurisdiction, including any objections with respect to the existence, scope, or validity of the arbitration agreement or the arbitrability of any claim or counterclaim. So why haven't here the parties contractually agreed that the question of the effectiveness of the napkin waiver is to be determined by an arbitrator, not the court?
Because, Your Honor, this arbitration provision is not the broad, all issues including arbitrability clause. The
Except that
provision-
it incorporates the rule that seems to say that, no?
But it states right in the text of the insurance policy that Granite drafted and gave to Amherst, it says disputes related to the interpretation of this policy. And here, whether it's by waiver or by modification, we're arguing that the enforceability of this provision is an issue before the court, and because we're challenging specifically the arbitration provision, that means the court decides the issue, not an arbitrator. And one thing I'd also need to point out, Your Honor, is that after this case was litigated in the trial court before Justice Timothy Walker, who granted summary judgment to Amherst, Granite did not move for a stay. They did not seek a stay to the litigation. So under the case law that deals with both modification and waiver, we've got extreme prejudice to the town of Amherst because this case is done. If this court reverses the Fourth Department decision and affirms the trial court order on the issue of arbitrability, this case is done. That's the most efficient resolution of disputes that one could ask for. Otherwise, now we would have to go back and arbitrate this case, or at least arbitrate the issue of arbitrability.
Is there a final judgment?
There is, Your Honor.
And is there an appeal taken from that?
It was, and then it was abandoned under the Fourth Department rules. Those 3 appeals were never perfected, and after 9 months, they're deemed dismissed with prejudice. Your Honor, I'd also like to point out that in our brief, and I won't belabor the case law, but our brief, page 13 to 17, we lay out the litany of this court's implied waiver by conduct cases. But in those cases, particularly Zimmerman versus Cohen and its progeny, Sherrill versus Graco, Primex versus Walmart, most importantly, Credit Suisse versus Pitofsky, the courts by and large say that waiver can occur by agreement or conduct. So it's not just conduct. Waiver by agreement occurs all the time. And I think this case recently, I don't recall if it was contemporaneous with the briefing on this case, or shortly before or after. Well, there was a 2015 case, Cusimano, decided the issue. The court decided the issue. It did not punt it to the private arbitrator. And then also Monarch versus National, 2016 case, same result. Thank you, Your Honors.
Thank you, counsel. Counsel?
May it please the court, my name is Mark Vosis for responding Granite State Insurance Company. Contrary to the position taken by Amherst, the Fourth Department did not issue a bright line rule that
Counsel, what's the point to the agreement on the napkin if you're required to go to arbitration anyway? What would be the point of it?
The purpose of the August 5th agreement was to carve out and set aside for another day the dispute between Amherst and Granite State. It was also to set forth the equation by which the parties' respective shares towards the settlement were applied to the accrued interest. Lastly, the August 5th agreement provided for the escrow account in which the disputed funds would be held pending a final resolution of the parties' dispute.
And how did the napkin agreement become a part of the policy?
It never did.
Yeah, well, that's what I'm asking you.
It, of course, never did.
And what's your response to that? Argue that.
The argument there is that, number one, it did not effectuate a waiver, and number two, there was no modification. Number three, the policy itself contains, in Section 6M, the exclusive mechanism whereby changes to the policy can be made. That is the exclusive mechanism. And the August 5th agreement does not comply with the terms of the policy.
Was
in
this
that
a
regard.
change, but was this a change to the policy, or was this a waiver of the right to enforce the provision of the policy in this particular instance?
The effect of the August 5th agreement, according to the Fourth Department, and in line with the controlling precedent of this court, was whether or not it affected a modification to the arbitration provision of the policy. It was not a waiver and cannot be considered a waiver.
Well, do you agree that waiver and modification are two different things? Let's
I do
start
agree
with
with that.
Okay.
I do agree with that.
And what determines whether it's a waiver or whether it's a modification? Would it have to use the word, I waive the right to arbitrate? Is that what's required? What would make this a waiver in your mind?
It's interesting that the courts do not provide parties with the exact language that needs to be utilized. However, it has to be an intentional relinquishment of a right that a party is
Can't you
otherwise-
modify an agreement by waiving a right that's under the agreement?
That's not the way the cases view these types of waiver arguments, Your Honor. In fact, waiver in this case cannot be based solely upon the use of the word litigate. The term litigate in and of itself is ambiguous as a matter of law. In fact, for the past 50 years, the appellate court, the judges of the appellate courts of the state of New York have used the term litigate.
Isn't that almost exclusively in the context of collateral estoppel and res judicata cases where we say full and fair opportunity to litigate? Isn't that where that comes from?
I don't believe that it is exclusively from those types of cases. However, the use of the word litigate to describe the act of resolving a contest of issues has been used, as I mentioned, and at least 77 judges of the appellate courts of the state of New
But
York.
you have to look at the context of that, don't you? It's never been used in this context.
I'm sorry.
Did you cite any cases in which it was used in this context in terms of making a distinction, if there is one, between litigation and arbitration?
Well, we cite the 1962 Court of Appeals case in Chupka, and of course, in that case, going all the way back to 1962, it was in the dissent, and in the dissent, it mentioned that the parties did not have the opportunity to litigate the question in arbitration or in court, thereby, in that case, at least.
I just clarify, is your position that litigate in this agreement meant arbitrate? That's what the parties meant? Is that what you're trying to say?
That is not what the extrinsic evidence
Oh, no,
shows.
Just looking at the agreement itself.
The agreement in and of itself is ambiguous as to what the parties meant.
Okay.
Amherst wants the
Well, if it's
court to
ambiguous,
believe-
don't we interpret it in the favor of
The town.
of the town?
I don't see why that is. These are two separate entities negotiating an agreement represented by counsel. This is not a situation where anything is construed against the insurance company. These are parties which were represented by counsel. at the
But
mediation.
don't we apply that rule to contracts generally, not just insurance policy?
Well, if that were the case, the first paragraph of the handwritten August 5th agreement was written by Thomas Jones, the attorney for the town of Amherst,
Saying they're the drafters.
of the provision
that
in
part.
question of the August 5th agreement. That's correct.
Well,
And
that's
the
an
use-
interesting question, because each party drafted one paragraph, right? And certainly, the attorney representing your company had an opportunity to see what had been drafted and to request changes. in that, correct?
Well, that's true, but there is an affidavit submitted by that attorney in which he stated that it was not his intent for the word litigate to operate as a waiver or a modification of the policy. And in fact, there is case law from this court in that negligence, oversight, or thoughtlessness will not operate to effectuate a waiver.
But is that the point that he thought it meant arbitrate? I'm losing your argument here, I'm sorry.
No, at the mediation, there was discussion as to whether or not Granite State would insist upon its contractual right to arbitration. Mr. Kapowski, the attorney for Granite State, informed the parties that he did not have authority to decide that at that time and would have to go defer the question to his client. There was another individual, the claims handler from Granite State, in attendance at the mediation, and similarly, that individual had to defer it and quote-unquote had to run it up.
So what are you
the pole.
saying that the intent was, to leave it ambiguous?
No, the intent was simply to carve out and preserve for another day the dispute between Amherst and Granite State concerning the amount at issue.
But the intent as to the word litigate.
The intent, it was
That's
not
not what, I mean,
resolved.
they didn't say, you know, we intend to carve this out and resolve this at a later time. They used the word litigate. So the question is that an intentional waiver? And
That is not an intentional waiver. Because
I realize that's your answer, but.
The intentional waiver has to refer in some regard to the arbitration provision at issue. The argument that a.
Okay, so
waiver
then
can
what
be
would
found-
this agreement have to have said? Let's follow what your train of thought there is. To actually constitute a waiver. The words, "we waive," is that what you needed here?
I believe that there had to be some other clear, unmistakable, and affirmative statement by either Amherst or Granite State that either party intended that the arbitration provision of the insurance policy would not operate to require the parties to dispute to resolve their dispute in that forum.
What about
That
the-
is absent in this case.
What about the waiver by conduct here? This has apparently been litigated to judgment.
The important, thank you for that question. The important thing to note there is that this is a pre-answer motion to compel. The issue that was decided by the trial court was issued on Granite State's motion to compel arbitration. None of the events described by counsel had occurred at the time that the trial court's order had been issued on May 15th, 2014. At the same time that once the decision came down, it became incumbent upon Granite State to interpose an answer and any other affirmative defenses and counterclaims in the case, while at the same time perfecting its appeal to the Fourth Department, which it did. Amherst raced to conclusion with the case without having the benefit of the Fourth Department reviewing the trial court's decision concerning waiver or modification. The trial court erred. The Fourth Department held that the issue of whether or not the August 5th agreement modified the party's contractual right to arbitrate was for the arbitrators. The effect of that modification on the trial court order was to nullify all proceedings that took place after it. It's as if they never occurred. Therefore, there is no longer a judgment as we currently stand. There was no summary judgment decision, and this dispute must be submitted to the arbitrators because the Fourth Department reached the correct conclusion and it should be affirmed. I see my time is up.
Thank you, Mr. Vosis. Mr. Schmidt?
Your Honors, with regard to that last point, there was never a motion for stay and the litigation has concluded, but in rebuttal, there were a couple of points I need to clarify. First, counsel cited the modification provision in the insurance policy as rendering the agreement to litigate inoperative. But on the record in the court below, counsel conceded that the modification provision only applied to the substantive provisions of the insurance policy, not the procedural points, and that was in the record at pages 21 to 22. Also, there was some question as to whether or not the counsel for the insurance company had authority to enter into the litigation agreement, and that was Mr. Kapowski. It was conceded on the record below that he did have full authority, and that's at pages 23, 32 to 33, and page 50. Finally, with regard to, not finally, I got 2 points actually, and I apologize for that. With regard to modification, and whether or not the litigation agreement affected a modification, there was performance under that. The agreement was executed, it was negotiated, it was merged into one agreement. It was 2 paragraphs. They didn't edit, add to, or subtract from the paragraph that Amherst drafted. It was mutually drafted, executed, there was performance, and as a result, Granite State Insurance Company received $10 million, all the money it was entitled to under its insurance policy. It received the benefit and then agreed with Amherst.
But so did you, just to interrupt that. Isn't the purpose of this agreement to get by the mediation hearing? Because there's a dispute going on over the $3 million. And in order for this fund to settle this, and you get 20-something million or whatever the payment out is to the town, they have to have resolution of this in some way. So it seems to me this agreement gets you by that, so you receive your payout from the insurance fund, and they receive their payout from the insurance fund. So I think to say they did it so they could receive their money, perhaps, but it seems the purpose of this entire agreement is so that you both can receive the undisputed distribution from the fund.
Absolutely, Your Honor, but we're not contesting this agreement. They are. We wholeheartedly embrace this agreement to litigate, and that whether or not it modifies the
You embrace
policy-
your interpretation of the agreement to litigate, but my point is really, if you step back up and you say, what is the purpose of entering into this agreement? It was to get you by the mediation, to distribute the funds, and to put off the resolution of the $3.13 million for another day. Because without this agreement, it seems to me the fund would not be able to pay out what it intended to pay out under the agreement.
That's accurate, Your Honor. But and this agreement was drafted by both parties. Finally, with regard to the issue of whether or not a subsequent agreement can either modify or waive agreement, I believe that's dealt with by this court in the Pitofsky opinion, Credit Suite versus Pitofsky.
Thank you, counsel.
Thank you.